Next is fast track special courts. Okay, you might have heard about this. Okay, mainly in case of POXO, etc. So, why is it news? Recently, the Union Cabinet has approved the continuation of fast track special courts for 3 more years till 2026. Okay, it was initially commenced during the year of 2019, and the scheme was extended till March 2023. Now it has further extended to 2026. Okay, it was initially commenced in 2019 for a year, and then it was extended later till 2023. Now again it is extended for till 2026. Clear? That's why we are discussing this, and it's in news. Okay, so what is a fast track court? Okay, we know that they are specialized courts, and with the primary aim is to reduce the amount of time, especially in cases of sexual harassment or sexual offences, particularly POXO Act. Okay, so they are the specialized courts established in India with primary objective or aim is to expediting the trial process for cases related to sexual offence, especially against the sexual offence against children, and mainly which is dealt with the POXO Act. Okay. Now, the establishment has prompted by the government regarding or due to the increased rate of sexual offences in the country. Okay, due to increased sexual offences, and if we see in the regular courts, there might be a delay. As we see regarding the judicial pendency is very high, right? So if it is dealt with if these cases are dealt by the regular courts, there may be a chance that these cases are may also get delayed. Okay, so these cases are something, or these offenses are something which need to be addressed at a earlier stage. First thing is that the justice should be delivered at an earlier stage, and the second thing is that there's the frequent or frequent justifications or the frequent exposure of the victims to these that like judgment or these cases will bring them into a mental harassment stage or a not emotionally detached stage. Okay, so they need to be pass through, or they need to go through the same instances every single time if it is in the other normal regular courts. Okay, the most important advantage of the special trial special court or the fast track court is that the case should be cleared within 1 year. So within the 1 year, the time the given cases will be completed or will be judged. Okay, so as we know, this came in 2019, but it came according to an act of central government, that is Criminal Law Amendment Act in 2018. And this act, one thing we know that it brought the fast track special courts. Other thing is it created or it introduced the stringent punishments, including the death penalty for rape cases, rape offences. Okay, clear? So the next thing is it is a centrally sponsored scheme. Okay, it is a centrally sponsored scheme. This means that the center and the state will contribute to the formation or the establishment of the fast track special courts, and it was followed or it was developed by the directions of from the Supreme Court of India in a suo motu writ petition. In which article writs come? Writ in which article? 32. Clear? So according to a suo motu writ petition by the Supreme Court directed the government to create this special courts. Okay, fast track special courts. And we know that since it is a court, the ministry which will be responsible is the Ministry of Law and Justice, and in that Department of Justice will implement the fast track special courts. Okay, but there are challenges regarding the fast track special courts. Okay, one is there is inadequate infrastructure and low disposal of inadequate infrastructure and low disposal rate. Okay, like we one of the major reason actually we established the fast track special court is due to the pendency of the regular court. Okay, the judicial pendency is really high, and that is the reason why and also the cases which we are here addressed is mainly of the sexual offences. So these cases are need to be addressed at an earlier stage or as soon as possible. So the same problems which the regular courts faced is also faced by the fast track special courts. Like special courts in India suffer from the usually designated rather than established as a new infrastructure. There is no infrastructure especially for the fast track special courts. Okay. So the judges who are in the regular courts will also be here. There will be an overburdening of the judges. Okay. Lead to overburdened judges who are assigned with other cases as well. Okay. Consequently, what will happen? The disposal of the cases will further delayed or they will reduce. Okay. As we know, there is a within 1 year the cases need to be addressed or delivered. Okay. But there is no adequate infrastructure. That means that we do not have a special infrastructure. Majorly when we say regarding the human resource, the judges. Okay. For the fast track special courts, the judges are same for the regular courts and the fast track special courts. So they have other works with them as well. So this will lead to overburdening of the judges and which will result in the delaying of disposal of the cases. Clear? Okay. Next is vacancies and lack of training. Okay. So this is similar to regular courts itself. One of the judicial pendency causes for judicial pendency we say is regarding the vacancy of the judges or lack of the infrastructure. Similarly, human resource and lack of the training. Similarly, here lack of judges is one of the reasons, or vacancy of judges is one of the reasons, and the other thing is lack of training. Okay, these courts are especially deals with the sexual offences. Okay, so the judges should also be trained accordingly to the specialized way to handle these cases. These cases are very sensitive, right? So there are training, lack of training, and also vacancies. As of 2022, lower courts across the India has a vacancy rate of 23%. Okay. So there are vacancies and also lack of training to deal with the specialized or sensitive cases. These are one of the other challenges when we consider the fast track special courts. Okay. There are other things regarding the prioritization of certain offences over others. Okay. Now, establishment of special courts in India is often determined by ad hoc decisions made by both the judicial and executive branches of the government. Okay. So ad hoc decisions means temporary or the initial for a small period of time, or for the initial requirement, only that much. Permanent and ad hoc, remember, we discussed this regarding the parliamentary committees for the purpose, ad hoc committees, and also, okay, permanent committees and ad hoc committees. Ad hoc committees are mainly recruited or created for the purpose only. Okay, so ad hoc decisions are made by the judicial and executive branches of the government. Okay, so these cases are something which are usually considered as prioritized cases. Okay, so there will be an arbitrary challenge of disposing such cases over others. Clear? Next one is limited jurisdiction. The courts are established, the courts have a specific jurisdiction regarding what they can deal with and what they are not able to, or what they can't. Okay. So there lies a problem in the jurisdiction of the courts. So there will be a limited jurisdiction of their dealing. Clear? This can lead to delay in the justice delivery, and lack of consistency in the application of the laws. Clear? So the jurisdiction is limited. That makes the justice delivery delayed. Okay. Okay. So we discussed regarding the pendency, right? There is a statistics that nearly only 19% of the cases which were registered in fast track courts were disposed in Delhi, majorly Delhi courts. Okay, only 19% of the cases were disposed. So this means that fast track courts need to dispose their cases within 1 year, right? So this means that at least the percentage disposal should be higher, but only 19% of the cases which were reported in the fast track courts were dealt or disposed. Okay, so that means that the delays or the objective with which the fast track courts were developed were not implemented properly or is not sufficient. Okay, there need to be a way forward. So what will be the way forward? First thing we said is regarding the inability or inadequate infrastructure regarding the judges, human resources. The judges are overburdened, etc. Okay. First thing we need to identify is the adequate infrastructure, including courtroom, support staff, modern technology should be provided to the fast track courts. Next thing, and also we said that there are a lot of vacancy, and also there needs to be a training on the part of the judges who are dealing with this sensitive cases, right? Okay. Now, for developing the adequate infrastructure or for recruitment or for training, we need funding, right? So additional funding should be allocated to the establishment and maintenance of these specialized courts. Okay. Next thing we discussed was regarding the disposal rate. For example, we also stated that in a Delhi fast track court, only 19% of redressal is done. So this means that there is a delay in the justice delivery, right? So they should. Another thing is the fast track courts should be focused on strict case management, thus reducing unnecessarily delays. Okay, which were maybe caused by the adjournment, and also they should ensure that the evidence is presented timely, etc. Okay, the fast track special courts should work accordingly to improve the efficiency and to prevent the delay in justice delivery. Okay, this thing we discussed regarding the specialized training, as these cases are mostly these courts mostly deal with the specialized or the sensitive cases, right? So there should be a specialized training both for the judges and the support staff. Okay, and also the vacancies should be filled. Okay, you can write the challenges, from that you can write the way forward. Okay,